I will make three very quick points. Mr. Khaitan touched upon the law, India and the UK, and our shared history in this regard. As Martin Luther King is supposed to have said, of course it's also ascribed occasionally to Malcolm X, if you didn't want us to be free, you should not have educated us. Having done so, and in particular in the Inns of Court, which if you visit any of them, any of the major Inns of Court, the list of luminaries of India's independence movement who studied the law in the UK is as long and as luminous here as it is back home in India. That connection is a vital part of what makes India a unique democracy, the only one in the modern age to have been a democracy by choice, even in conditions of abject poverty in 1947. No other democracy in the world became a democracy for all its people, with laws, with fully inclusive systems for all of its social groups and genders from the get-go. Every other democracy in the world became a democracy only after becoming wealthy. That, ladies and gentlemen, is connected with our heritage together. That is also a reason why in the 1940s, despite dire prognosis about the future of a coherent India, India was believed to be likely to survive because it had lawyers and economists running it. Of course, it's a different matter that in the late 1960s, everybody said the reason why the Indian economy was a basket case was because it had lawyers and economists running it, which might, of course, be a courageous thing for somebody to say here in a room full of lawyers, and I apologize at the outset if you're offended. The other part of it is that since the 1990s, and in particular in the current decade, in the last decade or so, the effort that has been made by the Government of India in partnership with our judiciary and our legal services sector to modernize and reform extensively India's laws. This has been nothing short of dramatic. And we really do invite our friends and partners from British law firms and the legal services in general, legal services sector in general, to come to India to explore what is happening here. We think the opportunity that is afforded by the transformation of India is today unique, because there is no other place in the world where so many millions of people are being lifted out of poverty and brought to prosperity in conditions of democracy than in India. And my last point, the FTA. Ladies and gentlemen, the India-UK FTA, which concluded successfully on the 6th of May, is India's most ambitious FTA to date. There is also the fact that it opens up government procurement on equal footing to British companies. It opens up a range of services sectors to both our countries to benefit from. And of course, frankly, where you do more business, you will have more disputes. And if we recognize that the process of dispute resolution is what sets democracies apart from authoritarian states and dictatorships, then that also means more business for all of us. Our objective, therefore, ladies and gentlemen, is to find ways in which, as India changes, transforms, and develops, the opportunity for more business, for more innovation to happen in settlement of disputes between businesses, and opportunities for the government to innovate in terms of creating new and more effective legislation to create space for business and to have the economy driven by private sector ingenuity. All of this is the future.
The recent signing of an India-UK trade agreement makes this a good time to have a very quick celebratory look at the relationship between the courts and arbitration in our two countries. Courts and arbitral tribunals are not competing institutions, but mutually supportive ones. Commercial arbitration proceedings not only respect party autonomy, but they also ease the burden on the courts, which must shoulder the full weight of those disputes unsuitable for arbitration, like criminal prosecutions, family and public law proceedings, and even multi-party, non-contractual commercial disputes. Meanwhile, the effectiveness and enforceability of arbitration as a dispute resolution mechanism ultimately depends on it being sanctioned and enforced, and where appropriate, regulated by national courts. But an arbitration award is usually stronger international currency than any national judgment when it comes to enforcement under the New York Convention. But if that does not mean a relationship of enmity, it does inevitably mean that fine-tuning that relationship is an occasional requirement, and the fine-tuning may occasionally take a wrong turn. Much of that fine-tuning is done by legislative reform. In the UK, the regime was recently amended by the Arbitration Act 2025, not yet fully in force, which, among other things, provides a clear rule under Section 6A that unless expressly agreed to the contrary, specifically in relation to the arbitration agreement itself, the law governing an arbitration agreement will be the law of the seat of the arbitration in question. That provision aims to cut through the complexities of the prior approach as outlined by the UK Supreme Court in Enka Insat v Sanyani ASV 000 Insurance Company in 2020. Namely, that is, to apply the common law on conflicts of laws, which would in the first instance tend to apply the law governing the contract as a whole, or, but only failing that, seek to determine the law most closely connected to the arbitration agreement itself, which would typically be the law of the seat. Likewise, I understand that in India, the proposed Draft Arbitration and Conciliation Amendment Bill 2024 will also make clarificatory amendments to the existing regime, including by making more explicit use of the concept of a seat of arbitration, although without adopting precisely the same rule as in the UK. In other cases, that fine-tuning of the relationship between the courts and arbitration is conducted by the courts themselves. And I want to mention just two cases, because they illustrate what I think is a common theme. The recent Indian Supreme Court decision in Gayatri Balasamy against ISG Novasoft Technologies in 2025 explored the scope of Section 34 of the Indian Act to hold that the set-aside power under that provision also encompassed a limited power to modify an award. As the court explained in paragraph 41 of its judgment, and I quote, "To deny courts the authority to modify an award, particularly when such a denial would impose significant hardships, escalate costs, and lead to unnecessary delays, would defeat the raison d'etre of arbitration. This concern is particularly pronounced in India, where applications under Section 34 and appeals under Section 37 often take years to resolve." End of quotes. Accordingly, arbitration awards could be modified to sever the invalid part of the award or to correct an error on the face of the record, modify post-award interest, or, but with great caution, under Section 142 of the Indian Constitution, even to do complete justice in the case at hand. My second example of the courts appearing to move away from giving complete deference to arbitration can be seen in the recent Privy Council decision, incidentally now enforceable in England because of a Willers and Joyce direction, in Sian Participation and Halimeda International in 2024. That case concerned the interaction between winding up proceedings and arbitration, in particular as the test to be applied by the courts in determining whether to stay or dismiss winding up proceedings based on claims which the parties have agreed to subject to arbitration, but where there is no real or bona fide dispute. The board held that Salford Estates and Altamart No. 2, a Court of Appeal decision in 2014, had been wrongly decided. That case had wrongly introduced a discretionary stay of a creditor's winding up petition or liquidation application, where there was no substantial dispute relating to the debt, merely because the claim was subject to an arbitration agreement. In fact, as explained in paragraph 89 of the board's judgment in the Sian case, quotes, "The contractual obligation embodied in the typical arbitration agreement is to refer disputes to arbitration for resolution. The negative obligation is not to have them resolved by any court process. Thus, the presentation of a winding up petition or similar liquidation application does not offend the negative obligation at all. It is simply not something which the creditor has agreed not to do." As the board continued in paragraph 99, the correct test for the courts to apply when exercising their discretion as to whether to make an order to liquidate a company where the debt on which the application is based is subject to an arbitration agreement was simply whether the debt is disputed on genuine and substantial grounds. And if it's not, then a winding up order should follow. As in the Indian case quoted above, the Sian case might at first sight look like a step back from the court's long-standing support of arbitration. But the decision was again justified by reference to protecting the raison d'etre of arbitration. The board in the Sian case noted academic commentary to the effect that the law, as had been laid out in the Salford Estates case, risked stifling arbitration by making creditors reluctant to sign up to a contract containing an arbitration agreement for fear that it would diminish the speed and effectiveness of the liquidation remedy against a debtor unable to pay where the debt itself was not really disputed. What I hope that demonstrates is that the courts in both India and the UK, including the Judicial Committee of the Privy Council, which sits in the UK but deals with overseas cases, are at least thinking carefully about how their role in regulating arbitration also promotes and protects it. Hopefully, that means that over time, both arbitration and litigation and the relationship between the two can only improve as each system progresses in a way that stimulates development of the other. And ideally, of course, that process will take place not just on a national, but on an international level as well, with best practices being shared via cross-border initiatives and conferences like this one.
Today, to address this gathering, especially at the time when India and the United Kingdom are enjoying one of the strongest phases of their bilateral relationship, the recent signing of the India-UK Free Trade Agreement in May 2025 makes a historical milestone. This landmark agreement is estimated to double the bilateral trade to almost US $120 billion by 2030. Beyond reducing trade barrier, the FTA will promote greater investment, innovation, and collaborations across key sectors such as technology, manufacturing, pharmaceuticals, and services, among other sectors. Friends, as we all know, under the visionary leadership of our Prime Minister, Shri Narendra Modi ji, our country is steadily progressing towards the goal of Viksit Bharat at 2047. One of the key pillars of this vision is creating a business-friendly environment. To support this, it is essential to have a dispute resolution system that is quick, reliable, and cost-effective. Honorable Prime Minister has taken several important steps to strengthen contract enforcement and improve the commercial dispute resolution system. These initiatives aims to make it easier to business in India and to build greater confidence among investors. Keeping in mind both current demand and future challenges, significant reforms have been introduced in the field of alternate dispute resolutions with the goal of making India a global hub for arbitrations. Over the past 11 years, the government has undertaken major legislative initiatives in line with this vision. To keep pace with development in arbitration and to make it a viable dispute resolution mechanism, the Indian arbitrations law has undergone significant amendment in 2015, 2019, and 2021. I would like to highlight some key amendments carried over in this Act. The Arbitrations Council of India has been established to promote institutional arbitration and grade arbitral institutions. Provisions now ensure confidentiality of proceedings, immunity for arbitrators, and clearly defined ground for challenging arbitrators. These initiatives ensure that arbitration in India becomes faster, more efficient and more trustworthy. India aims to position itself as a preferred destination for global business and investors. This vision now finds powerful enforcement through the strengthening Indo-UK relationship marked by historic free trade agreement signed in May 2025. The FTA not only opens vast new opportunities for trade and investment, but also signals a deeper strategic partnership based on shared values and mutual respect.
Honorable Shri Arjun Ram Meghwal ji, the Minister for Law, Government of India, Lord Michael Briggs, who had to leave to attend the court proceedings, Shri Vikram Doraiswamy, the High Commissioner for India, Shri Tushar Mehta, the Learned Solicitor General for India, Ms. Arjun Rathi Rana, the Secretary Law and Justice, Dr. N.G. Khaitan, Mr. Arun Chawla, Ms. Karishma Vora, and friends, a very good morning to all of you. The need for an effective, reliable, cost-efficient, and timely dispute resolution process has never been more pressing. Speaking as the Chief Justice of India, I may state that India has continuously aspired to become a hub of international arbitration by building a progressive legislative framework, a pro-informist judiciary, and robust institutional support. In 2024, the Government of India has proposed yet another amendment to the Arbitration Act, which aims to establish appellate tribunals in institutional arbitrators as an alternative to the courts with stricter timelines. It also seeks to statutorily codify the emergency arbitrations and further limit the jurisdictions of Indian courts in arbitrator appointment proceedings. The bill is currently pending for consideration with the Indian Parliament. Interestingly, the UK Parliament has also amended the English Arbitration Act 1996 through a 2025 amendment, which provides for statutory powers to the arbitrators for summary disposal of weak claims and clarifies the governing law of arbitration agreements. These legislative developments in both the countries underscore a shared commitment to fostering a conducive environment for arbitration, providing parties with the confidence to engage in cross-border trade. Indian courts have consistently upheld the principle as seen in the landmark case such as Bharat Aluminium Company, wherein a disagreement between the parties occurred on the appointment of the arbitrator. The petitioner sought the appointment of an arbitrator by Indian courts, arguing that jurisdiction existed since one of the parties was an Indian company, despite the arbitration being London. The Supreme Court rejected this contention, holding that the Indian courts have no jurisdiction over arbitration seated outside India. Emphasizing the principle of minimum judicial intervention, the court clarified that party autonomy and the integrity of the arbitral process must be respected in line with the international best practices. In Vijay Kariya, an award debtor sought to avoid the enforcement of a foreign award by contesting that the awards were in contravention of the Foreign Exchange Management Act 1999 and against the public policy of India. The Bombay High Court allowed the enforcement of the arbitral awards under Section 48 of the Act, rejecting the objection of violation of public policy. When appealed, the Supreme Court noted that Section 50 of the Indian Arbitration Act does not provide an appeal against a foreign seated award enforced by a judgment of a single judge of a High Court. And therefore, the Supreme Court should only entertain any appeal with a view to settle the law and not to adjudicate on the merits of the award. The Supreme Court further held that a breach of the fundamental policy of Indian law must involve a violation of legal principles or statute so essential to Indian jurisprudence that it cannot be disregarded. This judgment was significant because parties often challenge the arbitral awards on the ground that Payment directions violated FEMA regulations, especially where payments have to be made to foreign or non-resident parties. To avoid such objections, parties, particularly foreign claimants, would sometimes frame their claims as claims for damages rather than the claims for contract price. The court's decision in Vijay Karya marked an important step in safeguarding the enforceability of arbitral awards and preventing them from being undermined by technical objections. In 2023, while unanimously upholding the validity of an arbitration agreement, a 7-judge bench of the Supreme Court had held that an unstamped arbitration agreement was a curable defect, which could be sufficiently dealt by the arbitral tribunal itself. And erroneous courts at this stage, at such a preliminary stage, would undermine the efficacy and the objective of the Arbitration Act 1996. A constitution bench of this court in Gayatri Balasingh case underscored the importance of maintaining minimum judicial intervention with the arbitral awards. It held that the court has very limited power to modify awards which may be exercised only when the award is severable. By severing the invalid portions from the valid portion of the award and by correcting any clerical, computational, or typographical errors which may appear erroneous, thereby facilitating in not only bringing an end to the protracted litigation, but also saving the time and money of the parties involved. Incidentally, I had an opportunity to be part of all the 3 benches. Therefore, when the likelihood of an arbitral award being set aside or modified is minimized, the confidence in the arbitration process increases, leading to a more stable and predictable business environment. This greater certainty encourages the flow of business as parties are more willing to enter into contracts and engage in cross-border trade, knowing that the disputes can be resolved efficiently and with a degree of finality.
And now to invite Ms. Karishma Vora, barrister at 39 Essex Chambers, London, and a member of ICA's International Advisory Committee to deliver the word of thanks.
A judge, a minister, and an ambassador walk into a room. This sounds like a setting of a legal joke, but it is our speaker lineup today. It only shows how unified the judiciary and the executive are in shaping a faster and fairer dispute resolution system. Good morning. The Honorable Chief Justice of India, Justice B.R. Gavai, the Right Honorable Lord Briggs of the UK Supreme Court, the Honorable Law Minister of India, Shri Arjun Ram Meghwal, the Indian High Commissioner, Mr. Doraiswamy, thank you all for your insights. They have made the event meaningful. Thank you to the ICA, Mr. Khaitan, Mr. Chawla, Ashokji, Amit Padhi, Pinky Anand, Additional Solicitor General of India, Geeta Luthra ji. Your dedication has ensured that everything ran smoothly today. To all of the judges in the audience, including Chief Justice Wayne Martin of the DIFC Court, Dubai, also a fellow member of 39 Essex Chambers, Justice Dilip Bhosle, retired Chief Justice of the Allahabad High Court, senior counsels, former Attorney General, Mr. Mukul Rohatgi, Ms. Rathod, senior counsels, ladies and gentlemen, thank you for making it here this morning to hear our eminent guests speak. I have the honor of delivering the vote of thanks, and of course, I shall try to make it brief. Like Lord Briggs and Justice Gavai, I am also a first-generation lawyer. And first of all, I would like to thank them both for the role models that they have been in inspiring a generation of lawyers such as myself. Their bold decisions and relief-oriented approach has inspired us. Lord Briggs might not recall, but I was part of the legal team, the junior most on the legal team at the time, when he was a judge of the High Court. And the judgment Rainy Sky, which some of my English colleagues will recognize, was recent. He said to my lead barrister he was well aware of the interpretation of contracts and that he only needed to hear the last in the line of judgments, which was Rainy Sky. It showed me that one really needs to be very familiar with the authorities. And that learning has taken me forward at the English bar. Justice Gavai, I was privileged to be a junior counsel of the Bombay High Court some 18 years ago when you were a judge of the Nagpur bench. Your humane approach was well known then, and it continues to be popular today. Your courtroom is a welcome place for lawyers, juniors, and legal practitioners. Thank you for swiftly identifying and sifting through the crux of the complexities and getting to the heart of every case. Your decisiveness in granting reliefs has set the bar high. Both of our judges, Justice Gavai and Lord Briggs, have recently passed judgments on arbitration matters within the last 1 year on whether or not a court ought to vary an arbitration award. In the Indian decision of the Supreme Court of Gayatri Balaswamy and Novosoft, Justice Gavai led the court and held that the power to vary arbitration awards was permissible provided that it only corrected clerical errors, such as typos or computational errors. In the English decision of the Supreme Court, where Lord Briggs sat on the bench, called Sharp Corporation versus Vitera, Section 69 of the English Arbitration Act, which is a section that Lord Briggs referred to, was at the fore. And the court held that although it had the power to vary awards, it would not do so on facts, since that was an appeal on the law. There is a distinction between the English and the Indian Arbitration Act, because the English Act allows a variation. The Act itself allows a variation, but the court decided it would not exercise that power. It drew a line about the interference of courts in an arbitration award. That case, interestingly, which was the English case, involved an Indian party. It involved the import of dal, as many of you would know in the audience, or lentils, into the Mundra port in India. And that brings me to what connects both nations, which is trade. Honorable Meghwal ji, you serve in a cabinet of a country that not only has significant trade with the UK, but also are a minister of law when both legal systems have tremendous respect for each other. The comity between the legal systems came to the fore in a decision called Malhotra and Malhotra. I was lucky to be part of the legal case in that, and Justice Walker's judgment from the English High Court was adopted by Justice Patel of the Bombay High Court in a decision also called Malhotra and Malhotra. Wearing my hat both as a counsel of the Bombay High Court and a barrister of England and Wales, I have not only benefited from this trade, but I am grateful for the comity that both nations and legal systems have shown to each other. Mr. Doraiswamy, in his role as the High Commissioner, he has brought both countries closer by facilitating the India-UK trade agreement, and his recommendations of barristers has led to successful legal teams in London. Only last month, in the Antrix and Devas case, which was an appeal to the English High Court from an investment treaty matter, the English Commercial Court held that India had not waived its state immunity in terms of enforcing, or rather resisting, the enforcement of arbitration awards. And well, Mr. Doraiswamy is no longer here, but I wanted to thank him for the key role that he had played in putting together that legal team. I hope that both countries continue to collaborate on this, and we might take a leaf out of Lord Briggs's book when he, in 2016, conducted a modernization review of the civil courts. One of his recommendations included the establishment of an online court for low-value claims up to £25,000. I can endorse its success because I know a number of junior colleagues who have used it to sue for their unpaid legal fees successfully. One of them had had a baby recently and came to my room and said, in 6 months, this online dispute resolution system really delivered justice and he got paid. With that, ladies and gentlemen, I might sum up. Chief Justice Gavai and Lord Briggs lead the way in resolving commercial disputes. Indian law reforms have been given a great thrust under Shri Meghwal ji. The presence of the High Commissioner has driven several years of promoting trade between the two countries. Thank you all, and thank you also to the ICA for conducting successfully its third edition of the India-UK conference in London.
Thank you, Ms. Vora.